Our conversation this hour, as we hinted earlier in the first news fix, is around a looming strike from lawyers across the country tomorrow, ensuring that no lawyers will be in any court before any court in the entire Republic of Kenya. And we're speaking with Jacqueline Ingutiah, who is a JSC commissioner representing the Law Society of Kenya. She straddles that line. She sits on the Judicial Service Commission representing the Law Society of Kenya. So is it 1 foot in, 1 foot out? Is she going on strike? Is she? We'll be asking her exactly that. Good morning, Jacqueline.
Good morning, Mariam.
Good to have you in studio.
Thank you.
We usually start off with the quote of the day. So Phalaris will share the quote and you can say if you agree or disagree and if it speaks to you.
Great.
Welcome, Jacqueline. Today's quote is courtesy of a man that was the 66th Attorney General of the United States. And the quote reads, "A right is not what someone gives you, it is what one can take from you. A right is not what someone gives you, it is what no one can take from you." How does that speak to you?
I am a human rights practitioner, so I do believe that a right is God-given. And no one, including the state, has the right to take it away from you. So by being a human being, you're born with it. Yes.
It is God-given rights. Okay. And, you know, there's the LSK that's coming in here. It's a bench versus the bar. And, you know, to a lot of Kenyans who this matter could be, you know, new to them, they're just like, okay, these guys are beefing. I didn't know. What are the cracks of this? How did we even get here in the first place? To anyone that is hearing this for the first time, that the JSC and the LSK are tussling?
Okay, I don't think it's a new thing. It's a conversation that has been there for quite a while. And if you're to look back at the formation of the Judicial Service Commission, there was need to have representation of the Law Society of Kenya so that the Law Society of Kenya can be part and parcel on issues administration of justice. If you go back to the Waki report, they all spoke to the need of having representation and the voice of the Law Society of Kenya, the Judicial Service Commission. Again, if you look at Section 4 of the Law Society of Kenya, it has the various functions of the society. Specifically, 4 or around 5 of those functions speak to the role of the Law Society of Kenya on matters administration of justice and matters of representing the public around access to justice. So it's something that has been on for quite some time, but the conversation around accountability, integrity, independence, I believe the framers of the Constitution and Kenyans voted to this Constitution is that the Law Society is part and parcel of the discussions around administration of justice. Yes.
Now, the LSK says it has for a long time been pursuing some things, just to make sure that there is better and fair administration of justice in the country. But they have a number of concerns. Not 1, not 2, not 3, not 4, not 5, not 6, not 7, not 8, but 9 concerns as they presented them after the last council meeting. 1, integrity and corruption in the judiciary. 2, delays in administration of justice, saying advocates continue to experience delays in the hearing and determination of matters arising from case backlogs, frequent adjournments, delayed rulings and judgments, and other operational inefficiencies. They also talk about registry operations and court administration. Judicial accountability. Members are raising concern regarding effectiveness of the mechanisms for addressing complaints against judges and judicial officers, and they have called upon the Judicial Service Commission in the discharge of its constitutional mandate to ensure complaints are dealt with expeditiously, transparently, and fairly to strengthen judicial accountability. This, of course, complaint has also been discussed in the public domain, where they say complaints have been presented about judges and judicial officers. The JSC is seized of this matter, but then some of these judges go then to court and they try to block
them,
the JSC from advancing the investigations, or the JSC is just taking too long. You shall answer that because you are now the JSC. Professional dignity and working environment for advocates. Case management and access to justice. Specialized court processes and justice sector reforms. Needing enhanced institutional engagement. All those things that they are raising, including transition of the Judiciary pro bono scheme and pop-up briefs to the National Legal Aid Services, which you've talked about here, but the National Legal Aid Services for a long time. All these are concerns by the lawyers, which is why they're saying they have and they shall continue to look for various ways of addressing this, including court boycott tomorrow. Now, let's start with a big elephant that is in this room. Is there a legitimate concern by lawyers when they say that concerns about corruption in the judiciary are not being sufficiently addressed?
I am a lawyer myself. I'm a practitioner and also a representative of the Law Society of Kenya at the Judicial Service Commission. So I resonate 100% with the concerns raised by lawyers. And as I said, as a human rights practitioner, I do interact with the members of the public. So these are issues that members of the public have been raising when they visit our offices at KCHR. And what I hear my members through my leader, the LSK president and his council, is that we've had dialogue. And looking at the press statement, it's been ongoing for 2 years. So what the Law Society of Kenya is asking for is evidence-based solutions. I know the judiciary has done a series of things to address the concerns raised by lawyers, including the establishment of integrity committees, which members of the Law Society of Kenya at the branch levels are members to those committees, but still it has not addressed the issues. I'll give an example of the plea-taking practice in the country. A number of lawyers are no longer engaging in that practice because we've seen cartels, the issue of bail, bond, review of bail and bond terms in the absence of an advocate. When you want to execute your judgment, the post-judgment implementation, there's a challenge in that. So I do resonate with the advocates.
Sorry,
and
Jackie,
yes.
For us laymen, you take us slowly.
Oh, sorry.
When you say plea taking,
okay,
that advocates are no longer doing, what is that and why are advocates no longer doing plea taking? I don't even know if that's the correct.
Okay. Sorry, my bad.
What they doing
my bad. My apologies for that.
No worries.
Yes. So in a criminal trial, an accused person, a suspect is brought to court and a plea is taken, guilty or not guilty. And if an accused person pleads not guilty, then the court will, upon application of counsel for the accused person, or even the accused person, him or herself, will make an application for bail or bond. So the practice across the country, which are concerns that I've had from a number of lawyers, is that once the magistrate sets out the bail, for example, cash bail of 100,000, behind the scene you'll find court clerks or any other person or a cartel would go behind the scene and request the magistrate to reduce the cash bail so that something is given. No evidence is there, but you can see from practice. So you see a number of lawyers choosing to take up criminal briefs after the whole fiasco of the plea scene.
Right.
Yeah, so that is a concern.
Okay.
Yes.
I see how that is a very big concern.
The
Okay.
people who are in this cartel, are they lawyers?
It's a complex ecosystem. It's a complex ecosystem, and that's why I believe the issue of corruption in the judiciary cannot be fought only by the judiciary, but the judiciary has the highest standard. First priority is for the judiciary to ensure that all these things are addressed, because they are exercising these powers on behalf of Kenyans. So it is upon them. They have the first responsibility to ensure that the cartelism and these corrupt practices are done away with within the judiciary.
Okay.
Yes.
So in a case like that one, where lawyers are saying this has been the practice, this has been raised with the judiciary and the Judicial Service Commission over time, and it appears not to be addressed. Is it true that it appears not to be addressed?
I would say not really, because if you look at the anti-corruption committees, the ethics committees that have been set out, and when complaints are raised, and for the judicial officers, complaints go through the Chief Justice. I've seen the Chief Justice address those complaints as soon as they come. I have also seen High Court judges in cases of plea, them exercising supervisory powers to remedy the situation. But where I sit, I believe it requires a systems change. So the systems must be responsive. It does not require a judge to tell a judicial officer the right thing to do. It does not require the Judicial Service Commission to tell judges or magistrates or judicial staff on what is expected of them. So the Judicial Service Commission in 2020 gazetted the Code of Conduct. It requires judges, judicial officers, and staff to align their work around the code, the do's and don'ts. So that is one step the Judicial Service Commission has done in terms of setting the pace. On issues of complaints, if you look at the complaints that the Judicial Service Commission receives, they are complaints against judges. So there are two-tier systems of complaints processing. So there are those that the Judicial Service Commission has delegated to the Chief Justice. That's complaints against magistrates and complaints against judicial officers. So the Chief Justice is the one who starts the process. And if the matter requires disciplinary process, then it comes to the Judicial Service Commission. So for a long time, we noticed that we were not getting proper information. And as a Judicial Service Commission, we receive quarterly reports from the Chief Justice on the status of complaints within her office. On complaints against judges, those are the ones that come to the Judicial Service Commission. This financial year, last financial year, I'm speaking about the calendar year of the government.
Yes.
We had 164 complaints against judges. And out of the 164, 25 were those that were carried from the previous year. And 35% of these complaints were dismissed at preliminary stage. Here is when a party files a complaint at the Judicial Service Commission, requesting the commission to ask a judge to recuse him or herself, requesting a judge to give them an opportunity to present evidence, things that are outside the role of the Judicial Service Commission. So those ones are dismissed at the preliminary stage and parties are informed. There are those that we require the judges to respond. And after we have done that, from that number, 10% were dismissed after we looked at the responses from the judge. And 8%, we are waiting for the judges to respond to those complaints. And we have 4%, that's 7. The 7 complaints have been admitted for hearing. 7, we consider them sub judice. Eric, you did mention the issue of judges moving to court to get orders to stop the commission from proceeding. So 7 of them are sub judice, so we are not proceeding with the same. And then we have 64, that's 39%, pending preliminary evaluation. So once a complaint is received at the commission, the Secretariat would do a preliminary investigation and submit it to the committee. And this has been one of the things, as a chair of the Committee on Administration of Justice, I pushed to have a directorate of complaints and investigations to help the commission move on the issue of complaints. And then we have 2 cases that were withdrawn. And I would want to speak more around the issue of withdrawal, because sometimes you have cases that are in advanced stage. The commission has called witnesses and you're ready to proceed, and then the petitions are withdrawn. Yes, we have powers to, on our own motion, go out and do investigations and proceed with this matter, but it takes time. So those are some of the challenges that we have experienced as a commission. And we also need to understand that the commission is a part-time commission, and some of the recommendations we are hoping to achieve the moment the call for amendment to the Constitution are called upon, are asked, is to have a mixed membership at the JSC. So we have some permanent or full-time members and some part-time, so that they are able to...
Actually, when you say part-time, maybe just clarify that bit for us.
Okay, my apology. So all of us are engaged in other assignment.
Okay.
So the Constitution does provide for full-time and part-time. And for Judicial Service Commission is among those commissions that are considered part-time. The other one that is a bit similar to the Judicial Service Commission is Parliamentary Service Commission. But for them, they have both full-time and part-time commissioners so that they can help in ensuring that the activities of the commission are implemented. And lastly, on what the Judicial Service Commission has done is that we have developed, again through the committee that I serve, the Committee on Administration of Justice, the Judicial Service procedures for removal of judges. These are regulations that are currently before the National Assembly. The good thing with this document is that it helps the members of the public and even my colleagues at the Law Society of Kenya to understand the procedure. So it's a procedural document. It was developed after intense consultation, after looking at various decided cases. And it's also an accountability document which Kenyans can hold the JSC to account. You said you're going to hear and determine cases in 6 months. How come you have it 1 year down the lane? So it's a good document, and we hope once it's gazetted, it will be a better document or a better way within which the Judicial Service Commission can push for accountability.
We shall take a break, Commissioner.
Thank you.
When we come back, the Judicial Service Commission has done this, but the lawyers are not happy. Okay?
And there's one lawyer who's very happy. Senior counsel, Ahmed Nasir Abdullahi.
He's not very happy with the work that's been done.
No. He's happy that finally the lawyers have woken up to his plight.
Yes. What I'm saying is the lawyers are not happy with any of the efforts that have been made here by the JSC. And when the lawyers who are more than the JSC come to us at the public and they tell us they're not happy, then we're like, okay, there's an issue with the judiciary. So you'll respond to that. I mean, why has this not appeared to be moving the needle on fighting corruption in the judiciary sufficiently, to a way in which it addresses the public concerns? The Honorable Jacqueline Ingutiah is a commissioner in the Judicial Service Commission representing the Law Society of Kenya. And the Society's Council has said tomorrow, Wednesday, President Kanjama says tomorrow no lawyer is appearing before any court in the Republic. Why? Because these concerns have been there, they've been addressed over time, and they don't appear to be moving to a resolution. Why is that? We'll be back shortly. Do you have a matter in court tomorrow? If you do, just know that lawyers are saying they're not going to court, but the judiciary is saying courts will be open. So sasa, ujue vile utadil. Okay? The judiciary has said courts will be open through the spokesperson and deputy chief registrar. And the Law Society of Kenya has said lawyers will not make any appearance before court tomorrow. Now we have the commissioner of one of the commissioners in the Judicial Service Commission, Jacqueline Ingutiah, who represents the LSK, here to answer to some of these concerns that have been raised by lawyers. A number of them. There are actually like 10 concerns. And the Law Society of Kenya has said, we shall continue to engage in structured engagement. We shall seek judicial accountability through a performance framework. We shall seek the strengthening of the society's institutional capacity, branch participation and member engagement of the LSK members, and court boycott. The council remains committed to dialogue and institutional engagement. At the same time, it considers it necessary to take lawful and proportionate measures to advance judicial accountability and the efficient administration of justice. Accordingly, the council has resolved to undertake, general court boycott on the 22nd, targeted court boycotts. The society shall undertake targeted physical boycotts of court presided over by judges and judicial officers who have obtained court orders stopping or otherwise preventing the JSC or the EACC from exercising their constitutional mandate of investigating or processing complaints or allegations of corruption or misconduct against the judges or judicial officers. So they're saying tomorrow, boycott. Thereafter, targeted boycott at specific courts. Now, the JSC, as we've been told by the commissioner, you've been working. You've received 164 complaints. You've processed them. 7 are going, before trial, right? 7 complaints are going to hearing. 7 where they are now considered sub judice because those who are accused have gone to court and said, please, nothing of this matter should be discussed. 2 have been withdrawn, but 164 complaints. Sisi sio wazimu tukicomplain. Then you come and tell us only 7 have merit. Surely, Commissioner.
I hear you, Eric. But we have to work within what the Constitution has asked us to do. So the Judicial Service Commission cannot exercise power that is not granted to it under the Constitution. So we do not have power, for example, to ask a judge to transfer a case. That is a judicial power.
Yeah.
So it's a court that you make an application before the court, and the court will grant or not grant the application. So those are the majority, not majority, when I speak of 35%, quite a substantial number. So for me, I look at it, it's an issue of lack of awareness on those issues. But I know there's been discussions around decisional independence and incompetence. So what the Judicial Service Commission is doing around the issue of service delivery, because there's a distinction between the Judiciary and the Judicial Service Commission.
Yes.
So all the issues that have been highlighted by the lawyers speak to the services the Judiciary offers. But as an agency responsible for policy formulation and quote-unquote oversight, there are things the Judicial Service Commission has picked out and said, this must be done. And I believe that judicial accountability should not just be pegged on complaints.
Right.
We need to look at how the systems work. And the Judicial Service Commission is very keen on performance management. And what has the Judicial Service Commission done? Recommended to the Judiciary. For example, ICT. Can we reduce human interface? Yeah. We have seen the CTS working pretty well until post-judgment implementation. So there is a problem there. So there's still human interface. So lawyers are not able to extract their decrees. So we've recommended to the ICT department, remove the human out of this. We have also recommended to the Judiciary, we need individualized performance. I was appointed as the chair of the Committee on Administration of Justice, which for the very first time at the Judicial Service Commission, a non-judicial commissioner was given that role. And you can see this is our area as lawyers, area of administration of justice. So I attended PMMU, that's a performance management reporting exercise, and I would see judges, judicial officers receiving awards, and I would ask myself, quote unquote, qua ground, totally different. Yeah, you're receiving an award here, but you don't really carry your weight.
Yeah.
So what has the Judicial Service Commission done? Through the committee that I serve, we've made recommendation. 1, we need to have case weighting study. That is ongoing. So we need to measure what judicial time should a judge handling a non-contentious succession matter. Parties are in agreement. This is the property of the deceased, take 50, take 50. What time should another judge who is hearing a complex anti-corruption matter with 50 witnesses, should you weigh them the same? Not. So that study is ongoing. We hope to receive the report in 7 months.
Will this somehow, I don't know, work in tandem with the special courts we're seeing, either dealing with matters, gender-based violence and things like that, and where the period is also specified?
Yes. So the weighting cuts across all courts.
It cuts across those ones as well?
Yes.
Okay. And
but not tribunals?
We might get to the tribunals, because for now we are more keen on the mainstream, though tribunals are still now part of the Judiciary.
Yes.
We may get there, but we are more keen on that. And then the other thing that we have tasked the Judiciary to bring back is the customer satisfaction survey. And it will be rolled out in a month or so. The performance report only speaks to the numbers. 104 case clearance rate. But what does that case clearance rate mean to a Kenyan? Was there an effective, was there an accountable process? So we want to bring back the humanness in the process beyond the statistics. So that, again, is a recommendation from the committee that I chair. And then still on that, individual performance. The current performance measurement is at station level. So if you have a station with 2 judges and a number of judicial officers and staff, they are measured as a whole. So if you have a judge who carries his or her weight and another one who doesn't carry their weight, they are measured the same. So they are given an average. That is why you'll find in certain stations where you believe certain judges should be getting recognized for work they have done, they don't do that. So we have said every judge, after 1 year, you're expected to to issue 110 judgment and rulings. This is the end of the year. How many have you delivered? The same with magistrates. You are expected to have delivered this. And we are going beyond the target that was set about 10 years ago to look at what is the actual number of cases in your station. A judicial office, a judicial staff, that's a clerk, admin officer, you are expected to do certain registry operations. What have you done? So we are bringing the performance to the ground, from the cleaner to the highest office.
All the way up?
Yes.
Does that factor in the caseloads? Because, of course, some courts will have, way more active caseloads. So then it's not just a matter of, if I have 1,000 cases before me, I can only I can still only make 110 judgments a year, versus the person who has 200.
Yes. And that is what we're saying. It has to be based on a number, on a real number. The current performance measurement is the judge and the judicial officer, the ones who say, this is what I can handle. But not based on the actual number of cases. So the statistics should tell the Judicial Service Commission or even the Judiciary a story. So if a judge is able to only deliver 5 or 6 rulings in a year, what is the problem? Is it a capacity issue? Do you need more legal researchers? Or if you're able to deliver within the set parameters. So for me, and the committee and the Judicial Service Commission, we are saying performance is the way to go. And we hope the Law Society of Kenya can be supportive. My members of the bar can be supportive of this course. We had planned to release results of judges, how they perform, how many were able to meet the target of 110. And I know there is a court matter to that effect, so allow me not to speak further on that.
Proves the LSK, right?
I'm curious about the practicality of it, and this is against something that came from Senior Counsel Ahmed Nasiri yesterday, and he gave a breakdown of the number of days in a year that judges get to sit. So we have 365 days in a year. High Court, Court of Appeal, and the Supreme Court don't sit on Fridays, Saturdays, and Sundays. That totals to 156 days. Then we are left with 209 working days in a year. Judges take summer vacations of 45 days from 1st August to 15th September. They take 21 days Christmas leave from 22nd December to 15th January. They take 14 days Easter vacation. Judges take 30 days annual leave. Judges spend 30 days a year in a workshop, training, seminars, and foreign trips. Then he goes on to specify the Supreme Court. Average of 15 days on personal and family emergencies, and the average judge of the High Court and the Court of Appeal sit in a court a mere 54 days. So with judges working just about 54 days a year, and I want us to substantiate this claim, if at all then they are able to deliver 110 rulings, judgments, within, if this is the setup of how many working days they actually have in a calendar year.
Okay, I'm aware of, judges are entitled to leave. Judges, the summer vacation are provided for in statute. But for me, the bigger issue is not the number of days. When the JSC interviewed for you for that position, we gave you a reality check. The backlog, then hours you have to put in to serve Kenyans. Are you ready for that job? I'm not looking at it on how many days are you supposed to work. Is what do you need to do to ensure that the promise you gave in the presence of Kenyans, cameras were all over when you said, I am ready to work. And for me, I'll still go back to the issue of individual performance.
Okay.
So this
I have an issue though. Sometimes I think we just become unfairly judgmental. Now, the committee that you chair is proposing, let's go granular into scientific and look at the number of hours that you should take and so on and so forth. Do we consider, have you asked the judges the specific circumstances under which they end up with backlog of cases? Because you see, the interpretation that we'll get out of this, what the lawyers at the Law Society of Kenya is saying, what the Judicial Service Commission is imputing here, is that we have very many lazy judges and judicial officers. That it's laziness that's the issue. And so to whip them, we are going to actually clock them in and clock them out.
Yeah.
You know, at the end of the day, you came in at 3:30. You were supposed to have, produced X. Did you produce X?
So
you know, you are lazy. You know, that's the impression that we get. But having interviewed some of these judges, talk about, you're in a station, for example, in Nairobi, at the Milimani court, okay? How many cases are you handling in a day? Just hearing. You're hearing Albert Ojwang case for the next 3 days. Pop, 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 pop. That is over. You're hearing another big case for the next X. When shall you get time to retreat, to actually consider the evidence produced before you, to start working out a solid judgment? Right? Do we consider such?
Yes, and that
so judges come and tell us, man, I sleep at 3 a.m. and I'm up, I have to be in court early. It's a constant cycle.
I hear you, Eric, and that is why the case weighting study is very, very important. And this case weighting study is being done in consultation with the judges. We're not going to impose anything on judges. And the case weighting study will help us understand, ideally, how many cases should a judge handle? Do we need then to increase the number of judges? We have seen we keep adding more judges, but the complaints are still there. So we need to have data to inform us. How do we move when you're looking for when you're making decisions on recruitment, when you're making decisions on training, because some of this could be a training issue. So it's just to help us with the decision-making process. And anything the commission does, it does in consultation with stakeholders.
Okay.
LSK, judges, Kenya Judiciary, Staff Association. So it's nothing that we impose. So I do agree the work of a judge. Personally, I would not want to be a judge, and I've said that because the work is very, very demanding. It's too much.
And then you're called
you don't have a life,
all the time.
But you know at the time you're getting to do this job, what this job demands.
No.
It
Look, yes, it's valid, but it's unfair. It's unfair to come and tell somebody you knew what you signed up for.
Yeah.
And from the outside, it looked like, he's just carrying this load from here to there. And then you go and realize it's not just a 50-kilogram bag of cement that you're carrying from truck to construction site.
Yeah.
This bag of cement has spikes.
Yeah.
Right? Ukiokelea kwa mgongo inakudunga.
And there are no disclosures.
There are other things that actually you end up realizing. And the guy you're the one who actually is going to climb the truck, pick the bag of cement, come down the truck, take it to the site. You realize all these things as you're working, and then you come back and start complaining. When the judges come and tell you, look, we need more judges in this station. We need more magistrates in, for example, Nairobi. All we hear from the judiciary is once in a year or so on and so forth, we have an RRI where we bring in judges from other stations to come and handle a backlog of cases in this station for a week. Then they go back. And the station judge or magistrate is left to continue with the daily meal.
Yeah.
It's not fair.
I'll still go back to the issue, Eric, on case weighting. So once we get to understand ideally, how many cases should a judge handle? If you look at the issue of adjournment, the complexity of the case, and many other issues, we need to have statistics. And we cannot do that, we cannot make that decision until we have something, a basis within which we can use. So the reason why I'm speaking about performance tells a story. It should not be one that will be used to admonish, or it will give the Judicial Service Commission a basis within which to make decisions. So if a judge is not able to write 110 rulings and judgments in a year, why? And you'll find that judges will tell you, I don't have a legal researcher, or these cases are complex. So for us, you're saying that performance will help us do that. If a court clerk is not able to retrieve a file because the judge has the file in the chambers, the clerk will tell us, I was not able to retrieve 5 files because the judge retained the file in chamber. So and then we are able to know where is the missing gap. So it's not a punishment issue, it's something that will just help the Judicial Service Commission make better decisions.
Let me talk about the perception of the judiciary to the public at large and what this pending strike does to it. When you see people who have been conferred titles as big as senior counsel consistently, juris pesa this, juris pesa that. Finally, the Law Society of Kenya has seen what I've been seeing. That's a tweet from Ahmed Nasir today.
A senior counsel, a former president of the LSK.
Of the LSK. And you see these consistent, whether it's attacks on the judiciary or allegations of corruption, they chip away at the confidence that the public has in the judiciary, right? As a JSC, what's the actual fix here? Because you can say that some of these things are yet to be substantiated. These are how many complaints we have. These are how many actually have merit. But as a Kenyan, that's not information I regularly interact with. All I hear is juris pesa, juris pesa, juris pesa. Yeah.
Okay, 2 issues. I'll still go back to the issue of performance. Thank you. Because it is important for Kenyans to know what is the role of, for example, a clerk, the court admin, what are their job descriptions and everything. Not necessarily job description, what they do. And why the Judicial Service Commission tasked the judiciary to come back to the customer satisfaction survey is to get the feedback from the ground, so that you have both inward-looking and outward-looking evaluation of the commission of the judiciary. And I'm happy with for lack of a better word, the noise, because we all know the judiciary is the last hope for Kenyans. So for me, I don't feel sad. Okay, I feel sad because of the attacks. They may not be ideal, because we have very good judges. The judges who are doing an exemplary job, and one of them who is retiring this week, Justice Mushemi in Thika, she's done a fantastic job. There are judges who are doing everything within their ability. So it's just that few kichwa iki samaki ya kichwa iki something ikioza, yeah. So I know there are quite a number of judges, judicial officers, staff who are doing a fantastic job. But the call from my members, my colleagues, and the president and council is to just remind the judiciary, you are our last hope. You are our last hope. Please, let's see what we can do to improve.
I don't know if that will help with that public perception issue that I'm talking about, because it, like I said, it continues to chip away.
Yep.
And you'll come and you'll give us the statistics, but as long as people keep, screaming at the top of their lungs, or if tomorrow no one, people go to court and their wakilis are not available, why? Because we're striking against the judiciary. That's how it will be framed.
Corrupt judiciary.
Corrupt judiciary.
And
as we wrap up, because we'll have Charles Kanjama tomorrow, just speaking to LSK, and tomorrow being the big day, is the distinct. Are judges immune? When we speak about independence, does that mean judges are immune to, hence the accountability question that's coming up? From the JSC's POV and the numbers that you've given us, one would come to this conclusion that judges are actually immune from any kind of legal prosecution.
Judges are not immune, and that is what the Constitution also speaks to. The existence of the Judicial Service Commission is to make sure that judges are accountable. There's been this perception that accountability and independence are different. To the best of my knowledge, there are constitutional principles that must live together.
Sure.
And it is the role of the judges, and I've always said this when I meet them in colloquia or meetings, it is the responsibility of judges and judicial officers to fight for the independence of the judiciary by being accountable. It is not for the bar or members of the society to remind them. It's a constitutional office. Kenyans fought so hard to have an independent judiciary. So mine is to just urge the judges, the magistrate, the clerks to do the right thing.
Yeah.
Always, because it's an honor to serve in those offices.
It really should be. Let me just ask, as we close, mitigation. What tomorrow? No lawyers in court. Is the JSC or any other players between the LSK and the judiciary itself, anyone trying to mitigate what's happening and try to avoid this situation tomorrow? Because I think maybe if I'm here and I have a case at Milimani law courts, it might not be such a big inconvenience for me to go and find out that, oh, wakili isn't coming. Yeah. There are people who don't speak to their wakilis on a daily basis. They're traversing counties to go and, listen and have their case heard. But tomorrow they'll be unable to have that happen, and then they'll be pushed down another 3 months. It could be a criminal matter. There's so much at stake.
Yeah. So the issue of dialogue, I am a person who still believes that dialogue can work, provided there are timelines and a firmed up position on what we are going to do. So, I think there's still room for dialogue. But the JSC, we have done what you're able to do. We can still do more. And I'm just assuring Kenyans that we're on the right track. Sitting where I am, I believe we're on the right track. Yes.
I hope so. The deadline is essentially midnight tonight.
Yeah. Miracles happen even in a second.
I do not think it would be politically prudent for the LSK Council to call back that strike or to call down the lawyers. It is not going to happen. Tomorrow, the boycott must happen. Or else, Charles Kanjama and his council must go home.
Yeah. So I have a disciplinary hearing tomorrow at the Judicial Service Commission. So I'm going with the message of the 28,000 lawyers that things must change.
Things must change.
And if things don't change, the 28,000 lawyers, it will be the public 54 million. And we hope that things will be sorted before then.
Oof. Yes. Very striking numbers.
It's a big one. Commissioner Jacqueline Ingutiah from the Judicial Service Commission, representing the Law Society of Kenya. Somebody had actually sent a question. You see, the Judicial Service Commission comprises a majority of actors in this. Chief Justice, judges, Supreme Court judge, High Court judge, Court of Appeal judge, right? Magistrates, lawyers. Sisi wananchi hoi hoi.
Where's our representation?
Even the Attorney General lawyer should really constitute this thing. And have fewer lawyers and other professionals.
How do you oversight yourself? How do you oversight yourself?
To me, I hear where Kenyans are coming from with this particular debate, but I'll still go back to the conversations during the constitution-making process. All these discussions were made in the guide draft. They need to have, I wouldn't call it top-heavy, but majority of the members, out of 11, 5 are from the judiciary. For me, I look at it like once you are at the Judicial Service Commission, yes, you have been brought in by a vehicle, but you need to look at what you're expected to do as a Judicial Service Commission to promote an effective and efficient judiciary. So at times, there are instances where we are considered through the membership that we are a trade union. So the Judicial Service Commission is not a trade union. And look at Parliament, it's top-heavy MPs, and I've never seen that wrangle. So the moment we all understand that the JSC is not a trade union, but a constitutional commission that is expected to promote efficient and effective judiciary, we all then don't carry our stakeholders. We carry them as people whom we must engage, but not carry them as people we need to protect. Yes, thank you.
Way of putting it. Thank you very much, Commissioner. In the next hour, with me, there have been all this talk about investigations have been opened, file has been seized, file has been opened. No investigation no stone shall be left unturned. Mariam Bishar has a thing or two to say about that. Keep it here for that. It's 9 a.m. Good morning.